Welcome back, Chalk and Gavel listeners. Thank you so much for tuning in again. Before we get today's episode started, we've got some really exciting things that we wanted to tell you about. We are constantly thinking about ways that we can enhance our show to continue to deliver the exceptional education law content that you all want to hear. So we're going to tell you about two quick things. Chris, you want to tell us about the first?
Yeah, absolutely. Really excited about both of these. So the first one is a Chalk and Gavel teaching guide. So this is going to be a Google Doc that you can access through our website, chalkandgavel.com, that has all of our episodes broken down in a spreadsheet that talks about their topic, what they cover, some discussion questions, things like that, some potential teaching resources. All of that fun stuff is up there. So if you're thinking about assigning Chalk and Gavel for a class, or if you want to just tell a friend about an episode with a certain topic and you want to identify what episodes those might be, you can go to our website, find that teaching guide, and I think it'll be really, really helpful for folks who want to spread the word and share Chalk and Gavel with others.
Yeah, so it's a great resource for education leadership professors, but it could be great for anybody who's just really interested in this stuff.
Yeah, or educational leaders or teachers who are like, oh no, I just encountered this issue. I wonder if Chalk and Gavel's talked about it. Chances are we have.
Yeah, and you can find that in the teaching guide.
Yep, exactly.
That's great. Well, thank you for that, Chris. That'll be up on our website, so you'll be able to get the link to that document up on our website. And the other thing we wanted to tell you about is we are starting a Patreon page. We are really trying hard to grow the show and make it, again, something that is giving you the content that you all want. And to allow us to keep doing that, it would be awesome if you could head over to our Patreon page, show your support for Chalk and Gavel by becoming a friend of the show for just $2 a month.
A bargain.
Yeah. It's less than $25 a year. And, what we are thinking about doing here, we're talking about different subscriber-only benefits from things like bonus content.
BOCO.
Yeah, bonus content on a regular basis, as well as Chalk and Gavel swag, as well as
continuing to build the community, right?
Yeah, exactly. We're also just trying to build that community. So we would love it if you would show your support, not only by liking and rating and reviewing and following us on your favorite podcast platform, but please consider becoming a friend of our show on Patreon. The link will be on our website. It's also in the show notes, patreon.com/chalkandgavel.
Right. And that $2 a month is going to be so helpful to just cover the costs of producing Chalk and Gavel, right? Paying for our software subscriptions. We've upgraded our technology to kind of enhance our listening experience. So just all of those little things.
Yeah, we sound much worse in real life.
It's true. You have no idea how much editing Jamie has to do on my vocals. But, that $2 will go a long way to ensuring that we can continue to make this show and to continue to make it as good as you all deserve.
Yes. Okay, well, let's get to today's episode.
When can parents be criminally prosecuted for failing to send their kids to school? How fair is it to hold parents legally responsible for the actions of their children? What role do teachers and administrators play in addressing school non-attendance and truancy? Hypothetically, if I pull my kids out of school to go to Disney World and I forget to tell their school, am I going to jail?
Did you forget? Are you going to jail? Am I going to do this on my own?
I would hate to leave you hanging like that. I don't think I'm going to jail. Well, one, it's preschool. And two, I did tell the school that we were going to Disney World. So
you didn't forget. Okay.
No, I didn't forget. But, it's a good thing I don't live in Missouri, as we'll talk about in a second.
Yeah. So today we're going to cut class to dive into the murky waters of truancy with the case of the state of Missouri versus Williams. So while truancy cases don't really grab the headlines like student protests, or the state of Florida.
Had to get that in there.
Sorry. They do prompt us to think pretty hard about those fundamental questions regarding the role of the state in education and family life. Missing school can come with a hefty price tag. From school bells to jail cells, truancy is anything but trivial.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, so Chris, you got a bell ringer for us?
I do. And this is just a really fascinating situation that I think is going to be something that schools are going to have to really grapple with in the coming years. So this is an article out of the Washington Post, and it's about a Baltimore principal who made some headlines and went viral for an alleged racist rant that was recorded of this principal. But it turns out that the entire thing was an AI deepfake.
What?
Yeah.
So wait. So a principal allegedly went on this racist rant, and it turns out it was a deepfake?
Yeah. So there's this 42-second recording, allegedly between this principal and their vice principal. And it got out on social media. It got a lot of traction, a lot of people commented, a lot of people saw it. And months later, so this all happened in January, months later, it comes out that it was an AI generated voicemail of the principal's voice that was created allegedly by the former athletic director at the high school.
What?
Yeah.
It wasn't a student?
Nope, it wasn't a student. It was allegedly, and none of this has been proven, but it was allegedly I would assume, a disgruntled employee.
Wow.
Yeah. So this is wild. And, Jamie, you and I know kind of what AI can do and how it can take a 15-second clip of your voice and do some very, very crazy stuff with it. But just think about all of this. So when this all came out, the principal was placed on administrative leave following the kind of the community outrage at this alleged recording, right? Makes perfect sense. This recording comes out, they're the principal, they're a school leader, the school district needs to investigate and figure out what's going on. They place this principal on leave. So this fake recording had some really profound implications.
Oh my goodness.
I know.
How did they find out it was a deepfake?
I'm not clear. The article doesn't really make that clear, other than the principal was just kind of denying that it ever happened, right? And then one of my favorite parts about this whole story is that it was allegedly a conversation between the principal and their assistant principal. And the entire time this is going on, the assistant principal is like, I don't remember having this conversation, and I don't think he ever said those things to me, which he didn't, because it was an AI deepfake.
Yeah. Wow. That's crazy.
Yeah. So, there's a lot of potential implications here.
You think?
Right. Yeah. And it also kind of just emphasizes how much we need to be proactive about dealing with these AI issues. So deepfakes about students, and I know there's issues where there's deepfakes with students going around either saying or depicting them in compromising situations, whatever it might be. How are school leaders going to handle these things? And our laws, our policies aren't necessarily built to handle stuff like this. And that's actually one of the things that this article talks about is the laws. So Baltimore County PD is trying to figure out, what are we going to charge this former athletic director? What crimes are we going to charge him with?
Yeah, because they don't exist yet. The laws don't exist yet.
Right. I'm thinking here, it's kind of like impersonation, but he's not really impersonating him. But it's definitely, it feels if this were a civil lawsuit, it feels like defamation, right? You're publishing false things about them. So we're going to have to figure out how to deal with these things within existing frameworks, or we're going to have to introduce new laws, new policies, whatever it might be.
Right. Yeah. So speaking of, students in compromising positions, it reminds me of an article that I recently came across in the New York Times. And actually, it was covered in an episode of The Daily, the New York Times daily podcast that they do.
Okay.
And it was about students, high school students in New Jersey, creating deepfake nudes of their classmates.
Wow.
And basically, everything that you're kind of saying is that like this is uncharted territory. And schools, not only are schools struggling to respond to this because in many cases, schools don't even know that this technology exists.
Right. They're still trying to figure out how to make sure kids don't use it to cheat on homework.
Yeah, exactly. To your point, the laws, they talked about this in the New York Times piece, the laws don't yet really exist to encapsulate this phenomena, right?
Right.
And so they're looking at like, okay, well, what kind, like the child pornography laws, do those things apply? And in some states, it may only apply if it's not a minor who does it or something to that effect. Like,
okay.
There are so many nuances to these things, and trying to fit these deepfake things into the existing laws. One of the things that the New York Times piece was talking about was how, the movement on the federal level for this kind of stuff is pretty slow going. So it's kind of all in the hands of the states to ensure that their laws encompass these kinds of things. And I mean, listen, you're exactly right. Like this is something that schools need to
be proactive about.
Yeah, try to be proactive about. And schools are not, I would say, schools are not the most nimble of institutions, right?
No, they're massive bureaucracy.
They can't pivot on a dime. And so it's hard to respond to these new things that come out. Like it was the same with the internet, right? Like schools were very slow to effectively adopt computers and the internet and all this stuff because it's such a big bureaucracy and they're trying to figure out how to do things the right way, and technology moves so fast, right?
Right.
One of the interesting things about in this New York Times piece about that school in New Jersey was law enforcement, if I'm recalling this correctly, confronted the school to basically say, why didn't you report this? You all are mandated reporters, right? And this is sexual exploitation or whatever.
Right. Yeah.
And I think that the school said that their attorney advised them that they didn't have to because it wasn't real or something to that effect, because these deep fake nudes, it's not an actual picture of a person.
Yeah.
Or it was something to that effect. I'm not 100% sure if I'm recalling that correctly, but
right.
But the point is, like, this is new territory.
It is new territory. But, even though it's new territory, and even though you and I have kind of talked about the need for kind of a policy response or new laws or regulations or whatever it might be, like there's still a lot of things currently in place that could apply to this stuff. It's just we've got to figure out how it applies.
Yeah.
Right? Because like that's the story with all new technology.
Right.
Because, if we had to pass a new law every time there was new technology, we wouldn't have laws anymore, right? Like,
yeah.
Because we're still like, FERPA is a great example of this. FERPA was passed, the Family Education Rights Privacy Act was passed before the internet. And yet it's still the same law, right? So like we just have to figure out how these laws apply in these new contexts. So like if a school district encounters a situation like what you're mentioning happened in that New Jersey school district, like you can still apply your sexual harassment policy, because even though it's not actually a picture of that student, it's still sexual harassment, right? Like
exactly.
Absolutely.
Exactly.
And so like there's a lot of different things. And if we're thinking about like civil lawsuits, which is where my mind immediately went, like you've got defamation, you've got privacy torts, you've got all of these other kind of legal remedies. It's just, this is a new situation. So we don't know exactly how those things are going to apply in this new context.
Yeah.
Not to say they're not going to apply, because we can all kind of agree that like something is deeply wrong with this use of AI.
Right. One thing I will say is, if this sounds scary to you as school administrators, I get it. But to your point, Chris, I think it's probably fair to say, the internet also sounded very scary to school administrators when it came out, and so I would like to be an optimist here and say, we will figure this out.
Absolutely.
Right? We will figure this out. I mean, yes, it is scary. It scares me. Like, wow, like this technology exists, to the point where your story about the principal who went on this racist rant and it wasn't him. but it sounds like him.
And by the time the truth caught up, it had already gone all the way through social media and caused like a national stir. Right?
Yeah. So like if this isn't scaring you, that would be a little bit of a surprise to me. But at the same time, it's another piece of technology. I would like to think that we are going to figure this out and hopefully be able to live in harmony with AI.
I don't know if I want to say live in harmony with AI, because that makes it sound like AI is a co-equal participant in this. And I saw the Terminator movies. So anyway, that's
crazy, man. Wow.
Yeah. So thank you to Scott Roberts for sharing that article with me.
Yeah. Yeah. And listen, if you want to hear the daily episode from the New York Times podcast, and I believe it was on June 7th, might have been when that episode came out. So check that out. There's actually some interesting things in there. I remember thinking, I wonder if there's some Title IX violations here that the school did. And they didn't talk about that in the episode, but it was something that I was thinking of, the sort of the way they handled the discipline.
Yeah. Did they go through no, it's still the old Title IX stuff because the new regs haven't taken effect yet. But
right. But still, it's important to think. I think one of the things they talked about in that episode was like all of the girls who were affected by these deep fake nudes were called to the office. Like, obviously, this is going around the school. It's spread. Everybody's talking about it, right? They're all like whispering in the side and whatever. And they were all called to the office over the PA.
Oh, no. Like they said their names on the PA?
Yeah. But do you think they called the boys who were responsible for this? No, that was done very... And I believe that the boy only got a 1-day suspension.
No.
So I'm like listening to all this and I'm going, yeah, you might have some possible. Are you kidding me?
That's like,
stuff.
Oh my gosh.
Yeah.
A 1-day suspension for what is probably like a very serious crime.
Well, yeah. Like, can you imagine this sort of, these kids are 14, 15, 16 years old. Anyway, we could go on and on. Well, probably, my guess is there's probably going to be an episode or two devoted to this stuff in the next couple of months or years.
Oh, yeah. Yeah, no, I think we're going to have a case or two.
All right. Well,
okay.
Good stuff, man. Thank you for bringing that one up.
For sure.
All right, folks. So today we're going to talk about this case, the state of Missouri versus Williams. All right. This was a truancy case. It involves two parents, Caitlin Williams and Tamara, I'm not exactly sure how to pronounce it, Tamarae, LaRue. So we're just going to call these parents Williams and LaRue.
Always a safe bet.
Okay. They were both convicted of failing to cause their children to attend school on a regular basis, which was in violation of Missouri's compulsory attendance law. All right. So like I said, some of these truancy things don't capture the headlines. They're not really attention-grabbing kinds of cases, but they're important to talk about, right?
They are. Yeah, and this is, to put this in perspective, these are criminal convictions, right? Like,
yeah,
these parents were sentenced to jail because of the allegations that they failed to send their kids to school.
Yeah.
And after the pandemic, like, truancy and school non-attendance has become such a huge issue.
Right. Yeah, this is a big issue. They're criminal cases. In these cases, jail ended up being the response. In other cases, they're fines, things like that. It's actually, it's the reason we said it was sort of murky waters is because these truancy laws are kind of all over the place. Like it's pretty much all handled at the state level. There's very little federal guidance with respect to truancy laws. There's a few little things here and there, from the ESSA that ties funding to, keeping track of attendance and stuff like that. But for the most part, the detail about what is acceptable and what isn't, what is truant and what is not, is all determined at the state level, right?
Exactly. Yeah. Yeah. Because the federal requirements just kind of require you to track it, but they also don't tell you how to define the terms and things like that. So every state differs on, the ages for compulsory attendance, whether it starts at 6 or 8 and goes to 14, 16, 18, whatever it is.
Right.
They don't say what counts as an absence, what counts as an excused absence, an unexcused absence.
Yeah.
All of those things. So those are up to the states.
Yeah. And so a lot of states, have made those, the things that Chris just talked about very clear. Like what is an excused absence, what isn't an excused absence. And so obviously, like so many other things that are left up to the states, we've got a really wide range of how all of this goes, right? So, you've got states that are, like Alaska, for example, that are pretty lenient compared to many others. And then you've got states like Texas that are pretty rigid with their truancy laws. So, it's a pretty wide spectrum. And we're going to talk today about Missouri's.
Let's do it.
All right. So let's dive into the case here. So the first parent, Williams, we'll talk about her first. Okay. So Williams is the sole custodian for her daughter, initials EP. All right. And this took place during the 2021-2022 school year. EP was in first grade at the time. Okay.
So this is right after not after the pandemic, but like this is kind of in the midst of the pandemic, right?
Yeah. It's probably, it's like the first school year, again, like 2020, 2021, there were a lot of schools that were virtual, or even the ones that, were in person probably had good chunks of time where they went virtual, or specific classes went virtual. So 2021, 2022 was probably the first year that looked more
normal. Okay. So this is kind of where we're back to the new normal, right? Like, so basically COVID stuff is probably not driving this chronic absenteeism that we're talking about.
No, not as much as the year before, right?
Got it.
Okay. So 2021, 2022 school year, EP's in first grade. When EP was enrolled, mom checked a box that indicated that she read the student handbook.
The contract of adhesion.
Yeah.
Agree to the terms and conditions.
Yes.
I read all of those as an attorney, of course, obviously, right?
Yeah, exactly. Now, just a quick aside here, like just signing the handbook is not like the most legally binding thing, right?
Right. It's not a get out of jail free card for the district.
But it's very important to have.
Absolutely.
Look at it like layers, right? Like you want to layer the kinds of notifications of expectations that you want students and parents to have. And this is one important layer. All right. So here's what the handbook that Williams signed says about attendance. It says, the Lebanon School District believes that regular classroom attendance is important to the instructional process and that frequent absences disrupt the learning process. The state mandates that students maintain 90% or higher attendance each year in school, and that continued and valuable learning cannot take place without regular attendance. Poor attendance may limit accomplishments and reinforce a habit, which will handicap the individual in future education or employment. Therefore, in accordance with the laws of the state of Missouri, the Lebanon School District requires regular attendance of all school-age children each day school is in session. Now, there's a lot in there.
There is, but it all seems pretty straightforward, right? Like,
I would say straightforward in terms of the reasoning.
Really strong justifications for sure.
Exactly. Like, attendance is important, of course, right? But it goes into some detail about what it considers to be sort of required attendance, right?
Okay.
And it uses terms like regular attendance.
Which, as we'll talk about in a second, that's what Missouri's law says.
Yeah, exactly. It says, therefore, in accordance with the laws of the state of Missouri, the Lebanon School District requires regular attendance of all school-age children.
But then it also has that thing about 90% too, right? Like
90% of what? 90% of the week, 90% of a day, 90% of a month, 90% of what? So, we're going to sort of, as this case unfolds, we're going to show you how the court kind of wrestled with those things and unpacked them, right? So the handbook also goes on to say that it requires parents to encourage their students to attend school every day, to make every effort to schedule appointments for students when school is not in session. It is understood that it is not always possible, but it should be attempted.
Yeah, because all these doctors' offices are open from 9 to 5.
Yeah. I mean, we are lucky with my kid's pediatrician. They've got great hours, but like our dentist, it's
right.
Monday through Thursday, 7:30 to 3 or 4 or something, right? Like if he's going to the dentist, he's probably leaving early.
Right. Yeah. It's the same complaint I have with dry cleaners and banks.
Yeah.
I can't get to them if I'm working.
Yeah. Now, listen, my kid goes to the dentist typically twice a year. So it's not going to have a significant impact on overall attendance. But, anyway, there's like there's a lot of stuff to consider, but at least the handbook kind of recognizes that it's not always possible, but it's trying to basically tell parents, please make every effort.
Right. Should be attempted. Like, please try to do what you can to limit non-attendance or absences.
Right.
Okay.
And when you can't, just please notify the school. It also says absences caused by personal injury or illness within the family that necessitates a student be absent, or extenuating circumstances or emergencies or things like that. Just communicate that with the school. And it did suggest that vacation time is during non-school.
Okay. So that trip to Disney World, need to reschedule that.
Well, I mean, it was over Memorial Day. So in part.
In part, yeah. We still pulled him out of school for a couple of days, but you know. So the emphasis here is on, we recognize that sometimes you're going to have to miss school. Try to do what you can not to miss school. Yeah. And if you're going to miss school for whatever reason, let us know. Let the school know whether, you're going to have an absence, a tardy, early withdrawal, whatever it might be. We just need to be in the know.
Yeah. So let's talk specifically about EP's absences and how Williams, the mom, took care of it. So in November of 2021, EP had reached 6 absences.
Okay. So that was about, 3 months into the school year?
Yeah. three and a half, 4, somewhere around there.
That seems... 6 absences in that time doesn't seem that out of line.
It doesn't seem that out of line. It seems like a nice point for the school to just send a little reminder saying, we're a few months into the school year. Just FYI, we've got 6 absences on file.
Yeah.
So basically, and that's what the letter did. It informed Williams of the number of absences, which translated to approximately 85%. So translated to approximately 15% absence.
Okay.
Remember that 90%.
That 90% threshold, yeah. Okay, and that's so far in the school year, she's missed 15% of, okay.
Yeah, basically. And it reiterated the Missouri Department of Elementary and Secondary Education's rule about 90%. And it said, if you have documentation indicating the reason for an absence, please submit it to the school. Okay. So to me, that kind of it reads as if the school was saying, listen, if there's a legitimate reason for these absences, just let us know. I mean, it's not really saying we'll take care of it or we'll wipe the slate clean or we'll whatever, but it's kind of implying like, please, if there's a legitimate reason, just let us know.
Right. And it's nice that the school is reaching out right before... Yeah. Because I can imagine, you get to the end of the school year, you ramp up a bunch of extra absences, and now the train has left the station. There's nothing you can do about it. So, I appreciate the school being proactive here.
Yeah. And then they were proactive again after EP had accumulated another 3 absences over the next few weeks. So in December, Williams got another letter indicating that EP now had 9 absences.
Mm-hmm.
Same kind of letter.
Okay.
In early March of 2022, Williams got another letter saying that EP now had 15 days of missed school.
Okay.
Right?
And so the rate of absences seems to be pretty consistent here.
Yeah.
Right? We had about 6 in the first 3 months, 3 in November, December, and then another 3 in the, January, February, March.
Or another
6.
Another 6, yeah.
Yeah.
So, it's looking, it's like she's missing a few days of school.
Every couple of weeks.
Yeah, every few weeks, right? At this point, these 15 absences, the first 6 had reasons attached to them in the school records.
Okay.
Mom left voicemail because EP was out sick. Mom called. EP has an ear infection. Mom called. EP is sick. Mom called. Bad cough. Mom called. Dentist appointment. Mom called. Ringworm.
Oh, that's rough.
Yeah. That took us through the first absence of November. All right. Every subsequent absence between the middle of November and the beginning of February, which came out to 9 absences, didn't have a reason provided at all.
Oh.
So mom basically just stopped calling the school, providing reasons, anything like that.
Okay. So we have no information about why EP was missing school for those. Okay.
No. Now, according to the school, EP's lack of attendance started to affect her performance in the classroom.
Understandable.
The attendance advisor contacted Williams to communicate the need to get her child to school and to make it a regular occurrence. Okay. Apparently, Williams never explained to the attendance officer why EP was not in school.
And that's something that we don't have any information about, right? Like, we don't know anything about Williams's context to kind of understand, like, what's going on here.
Right.
to make it difficult or what's going on in their lives at all.
Right.
To like kind of contextualize why EP isn't in school.
Right. And the court records do not provide any sort of indication as to what might have been going on.
Right. And none of that was communicated to the school too.
Correct.
Which I think, that's probably the larger issue.
Exactly. So in this particular case, we're going to talk about LaRue in just a second in her situation. But in Williams' case, she was found guilty of a Class C misdemeanor for violating the compulsory attendance law. And she was sentenced to serve 7 days in jail, which, in the court records, it says it ran concurrently with another unrelated sentence. So something else was going on. We don't know anything about it.
Right. Okay. So she was already in the criminal justice system for something else.
Correct.
Okay.
And they allowed the truancy sentence to be served concurrently.
Okay. So at the same time as she was already kind of serving a sentence for something else. Okay.
Yeah.
And then, so like the way this gets to a criminal charge, so the school is, enforcing this attendance policy. Typically what happens is the school then has to contact and basically make a truancy reference or something like that to local law enforcement, who will then investigate if they need to do more investigation, and then they'll bring the criminal charges. So it's not the school bringing charges, but the school is basically notifying local law enforcement like, hey, we've got this student who isn't in school. Can you follow up and, if necessary, file charges? So they bring truancy charges. And so that's kind of how the parent ends up getting charged here into the criminal justice system. Some referral from the school district.
Yeah. And, as we'll talk about, a little later, the school appeared to do what we kind of advise schools to do in these situations, and what most schools actually do, because, it's part of their policies and their procedures. Like, they don't just allow kids to miss school, and then once they get a certain number, they just refer it back to state authorities. They reach out, they send letters, they have attendance advisors who call, they do home visits to try to see what's going on and how they can help and support and get kids to school. So theoretically, the way the system is set up is, the school will make every effort to keep the kids in school. And when they've sort of exhausted all of their resources and they haven't seen a change, they have the ability to hand that over to the state and say, listen, we've tried, but nothing has worked or whatever. So, please do with this what you will.
Yeah. So let's try a different enforcement mechanism.
Yeah.
Right. And, and we'll talk about whether that's an effective enforcement or even like let's say an appropriate enforcement mechanism too. But because I think like what you said about the school really getting involved to address, the reasons for the non-attendance, to offer support and all those things. And like, with the Williams situation, we've kind of got that. Like, they've got the letters, they've got these attendance officers who are talking. And I think like with the LaRue situation, it comes out even more. Like, the school is doing a lot to try to get this kiddo in school.
Yeah.
So let's talk about LaRue.
So LaRue, very similar situation. Her son, initials AL, was enrolled in kindergarten in that same school district. Okay. Did the same thing, signed, checked the box that indicated that she read the handbook, all of that stuff. So, so far we're talking about two very young kids. Okay. So it's just important to remember that the circumstances around attendance and truancy can often be very different when you're talking about kindergarten, first, second grade students versus 14, 15, 16, 17-year-olds, right?
Right. Absolutely.
And the parent's role and responsibility is obviously a little different.
Yeah, you're right. Because we're talking about a first grader and a kindergartner here. And I don't think we mentioned it, but in both these cases, Williams and LaRue are the sole custodian for this child. So, it sounds like it could be a single parent household. And so, Jamie, to your point, like with children that age, they're not, able to kind of like direct their own lives in the same way as older students are. They're not driving themselves to school. They're not taking themselves to the bus stop, right? Like, right. So it falls more on the parent. And I think that's one of the things that this statute that we're going to talk about in a second kind of alludes to. Mm-hmm. Because, like when we're talking about non-attendance, there's the truancy side, which is what the kid could be charged with if they don't go to school.
Right.
But then what the parents were charged with here was their failure to send their kids to school.
Yes.
So there's kind of like two potential crimes, if you will, baked into this situation.
Yeah. So basically, AL was enrolled on September 9th, and apparently the attendance issues started pretty much right away. So much so that an assistant principal contacted LaRue to ask what supports the school could provide to assist the child in attending and reiterated the importance of school attendance.
Nice.
So just what we talked about, right? Like the school's reaching out to say, hey, how can we help? Here's the resources we have. What can we do?
Right.
In November of 2021, AL had reached 6 absences. So very similar to Williams' kid. LaRue got a letter, same as Williams. In mid-January, LaRue got another letter from the school because AL had accumulated 9 absences by that point. So again, very, very similar situation. To make a long story short, ultimately about 13 absences were recorded. 7 of them were unexcused or unverified, didn't have reasons provided. It's a very similar kind of situation to Williams, right?
Yeah, and it sounds like the district has some pretty specific policies around this. Like you get a letter at 6, you get a letter at 9.
You get check-ins from school administrators or other officials to say, what can we do? Remember, this is really important to have your kids in school, what's going on. But in both cases, the school said it was never made aware of any particular reasons for these absences, for these, this accumulation of absences. And in LaRue's situation, the school even specifically said if they had been made aware of any particular medical reasons, they wouldn't have pursued the absence issue any further.
Interesting.
Yeah.
Okay.
The attendance advisor testified that she talked to LaRue on multiple occasions, but again, no sufficient reasons were provided for the school. And so, like Williams, LaRue was found guilty. And she was sentenced to serve 15 days in jail, but that sentence was suspended and she was placed on probation for 2 years instead.
Okay, so wait, time out. She was sentenced to 15 days in jail for her child having 7 unexcused absences.
Well, how's the kid going to get to school during those 2 weeks, right?
So she was sentenced to more days in jail than the student missed days of school. So the student missed like 13 total, 7 were unexcused. So like I struggle with this idea. Yeah, like Jamie, what you just said. How's the kid going to get to school now, right? This is a single family home or single parent home, potentially. We don't know the context, right? We have no idea what is keeping or, what obstacles this family might be experiencing to get these students to school consistently. Like we know nothing about this. And I think, my big issue here is like the criminal justice system is a very blunt instrument in a lot of ways, right? Like it is very punitive in nature.
Right.
It operates under the assumption that you are in control of your actions and that you can change them if the threat of punishment is sufficient to kind of change the calculus about your motivations. And that's kind of what it's operating under. And like, I don't know, I want to know more about these parents to know if that holds true. Like, would they do something differently with that threat looming over their head? Or is it just something that like is beyond their circumstances that they can't control that is causing all of this to happen? So like using the criminal justice system to kind of address this is something I struggle with, but I also recognize that like, this is a larger social issue. It's not just something that schools can really handle or manage on their own, right? Like, because why students are not attending schools, I don't know how much control or influence other than offering support schools really have over that.
Yeah, I completely agree. And on top of that, the sort of potential ambiguity in truancy laws in states and the discretion that schools are given and districts are given to enforce those laws also really muddies the water. Right?
Absolutely. And that's a big part of this case.
Totally.
Yeah.
Yeah. Like, for example, it's, 90% is the threshold. Is that 10% that you are essentially allowed to miss? Is that only unexcused absences or does that apply to everything?
Right.
Anyway, lots to unpack here. So let's see how the courts kind of handled it. All right.
Yeah. And I think that's a good preview for what the court does here. So we are in the Supreme Court of Missouri. So this is the highest court in the state of Missouri. So it's the highest state court because this is based on state laws. That's why we're in state court. And this is the parents here essentially appealing their criminal convictions, challenging them on 2 grounds. One, they're saying, you didn't have enough evidence, state, to convict us under these criminal penalties.
Really?
Yeah, right. That's what they're saying.
We have receipts. We have every single day listed that your kid missed along with the reasons or lack thereof that you provided.
Right. And that's kind of their argument is that's what the school is saying. Like the school and the state is saying like, no, like we can point to all of these days of school that they missed.
Right.
We can point to all these things that we did to get them into school. And the parents kind of come back and say that, well, that doesn't really get you anywhere because the law is ambiguous. So like it was 90 days and you never proved that I missed 90 days. And also there's a really important caveat here, which is you didn't prove that I had the sufficient mental state to violate the law. And so, I'm going to drop some Latin on you. You ready?
Yeah.
Mens rea. So it's Latin for guilty mind. Most criminal statutes require that you have what they call a guilty mind when you violate criminal law. Basically just meaning like
intent.
Yeah, it's an intent requirement, right? Okay. Or if you want to get really fancy, it's a scienter requirement.
I don't want to get fancy, but thank you.
This is right up there with 12b6 motion, right? Yeah. Just drop these in casual conversation at the dinner table.
So basically it's just saying that we have to know that this is a law that we are breaking, and we have to basically not care about that.
No, that's not it, because ignorance of the law is no excuse. You'll hear that phrase all the time if you go to law school.
Okay.
It's not that you knew it was against the law and you did it anyway. It's that you intended to do the thing that was against the law.
Mm.
So here there's
a subtle nuance there. Yeah.
Right. Yeah. Because it's not like, I don't know all of the laws out there. I don't think anyone knows all of the laws out there. Right. But most of the time we follow them anyway and we do okay. It's the question of like, did you mean to do the thing that was against the law?
Okay. So it's not necessarily about your knowledge of the law. It's like, regardless of whether or not this thing was against the law, did you mean to do it?
Right. Exactly. Yeah. And so the parents are essentially arguing that the state failed to meet their burden of proof. So in a criminal case, you have to prove beyond a reasonable doubt that the person committed the crime. And so that essentially means like there's no other reasonable explanation other than that the person committed the crime. And so this is the highest burden of proof in our judicial system. So, in other contexts, we've talked about preponderance of the evidence, which is like more likely than not. Mm-hmm. Sometimes you'll have clear and substantial, but beyond a reasonable doubt is a really high standard. It's the one we use in criminal cases because we want to make sure that innocent people aren't getting punished for crimes.
Right.
And the parents are basically launching this two-prong attack. One is we didn't have the right mental state to violate the law because we didn't knowingly fail to send our kids to school. And then the second prong is that, you didn't have enough evidence that we failed to send our kids to school enough.
Okay, wait. So on that second point, which we sort of already touched on, they're saying you didn't have enough evidence, which, our response, which was similar to the state's response, was, yeah, we did.
But the school kept the receipts.
Yeah, exactly.
Right.
The first point that you mentioned was
they didn't knowingly fail to send their kids to school.
Yeah, they didn't knowingly fail to send their kids to school. Like, really? So was it a case of you weren't around? Are you trying to say, maybe I wasn't at home, I was at my job, I told my kid to go to school to get on the bus, but they didn't do it, so I didn't know that they weren't going to do it.
Right.
We don't know, right? Like, it doesn't go into that level of detail. But like, to me, somebody saying, I didn't know that my kid was not going to school.
For a kindergartner and first grader, that's a tough argument to make.
It is, exactly.
Right.
Like, I think it would be a much more reasonable argument to make from a working parent of a 15-year-old kid, right, who has the ability and the level of responsibility to get themselves to school in most circumstances, at least more than a kindergarten or first grader would.
Right. And that's what the court ultimately decides here.
Okay.
For exactly kind of what you're articulating, right? Like the court looks at this and says, knowingly violating the law, all that requires is that you acted with knowledge that a certain outcome was practically certain to happen. So you acted knowing that something was going to happen. And here, like by not taking the kid to school, who is a kindergartner or a first grader, or like, ensuring they got on the bus or whatever it might be, like that's practically certain to result in them not attending school.
Yeah.
And the court just looks at this and says, you signed the handbook, the school contacted you a bunch, you are the sole custodian for this child, and the child is very young and you have substantial control over them. So like all of that kind of points to the fact that you knew what you were doing was going to result in them missing school.
Right.
And so, yeah, so I think like, ultimately their sufficiency of the evidence argument, I think is their weaker argument, but wrapped up in the insufficiency of the evidence argument is their argument that the statute itself is vague. And it's vague enough that the parents argue that it didn't give them reasonable notice of what conduct was going to violate the statute. And this goes back to their argument about not having the right mens rea, the right mental state, is like, how can I knowingly violate something that I don't know what it means?
Right.
Or that like, is ambiguous in this way. So that's kind of I think that's their stronger argument here is that the truancy laws are unconstitutionally vague.
Yeah. All right. So what else?
Right. Yeah. So like their vagueness challenge, and this is the one that I think actually has some potential to it. The court ultimately decides it doesn't, but we can pick that apart here in a second. So the void for vagueness doctrine essentially just requires that criminal laws be sufficiently definite to give people an understanding of what is prohibited and what is allowed. So it's basically the requirement that your criminal laws need to be clear enough to give an ordinary person an understanding of what they can and can't do. And I like that requirement. That seems really useful.
It's a good requirement. And to me, it kind of sounds like, you know what, we're not going to scrutinize this 90% kind of thing, right? Like it's not, in this case, it's not necessarily about that number, right? Like,
well, that's the issue. That 90% thing, that's not in the law. So here's what the law actually says. And I want you to be the judge. Is this law vague?
Okay.
So here it is. Any parent, guardian, or other person who enrolls a child between the ages of 5 and 7 in a public school shall cause such child to attend the academic program on a regular basis. Non-attendance of such child shall cause the parent to be charged with a misdemeanor.
Okay.
So that's the statute.
All right. And you want me to tell you whether or not I feel that is vague.
Hit me.
So, I mean, obviously the one phrase in there that is potentially problematic is attend the academic program on a regular basis.
Ding, ding, ding. Exactly.
Right? Like, what does that mean?
Right.
On a regular basis? Does that mean like, listen, as long as I'm attending 4 out of 5 days, that's regular. Especially if it's the same 4 days, if I'm going to school Monday through Thursday every single week, I mean, you could define that as regular, right?
Yeah. On Wednesdays, we wear pink. Exactly. Like that is regular.
Yeah.
And that's exactly what the parents are arguing here. They're arguing that that phrase on a regular basis is so vague as to allow for the state to engage in arbitrary and discriminatory enforcement. And it doesn't give a person of ordinary intelligence knowledge of what is or is not allowed.
Yeah.
And so there's this issue of like 90% attendance kind of floating out. That comes from the State Department of Education kind of
interpreting the regular piece.
Yeah, they're giving advice to school districts, but the statute itself, which is what the state here is enforcing, they say like, that doesn't change the meaning of the statute. Just because the school's policies said 90%, that also doesn't change the meaning of the statute. So we need to figure out what the meaning of the statute is.
Okay.
And the court looks at it and says, they go pick up a couple dictionaries and they say that regular is defined as, steadiness and uniformity of conduct and the lack of unexplained or irrational variance. And they conclude that, based on those definitions, that regular means having the child go to school on those days the school is in session.
That's interesting, Chris, because that second part of the definition where it says the lack of unexplained or irrational variation, I'm kind of surprised that the court looked at those definitions and sort of interpreted them in this case as concluding that regular means having the child go to school on those days that the school is in session. Because to me, that implies that even if you just miss one day, that's legally a problem. Whereas it could have focused a little bit more on the definition of regular that focused on the lack of unexplained or irrational variation, because you've got all of these unexplained absences, right?
Right. And that's what the court's doing here. They're only looking at the unexcused absences. They're actually very clear that, like, look, we're not looking at the excused absences or the ones that the parent notified the school why the student was missing, because the attendance law here has some exceptions for different things, like if you unenroll the student or if the student has some like mental or physical incapacity that doesn't allow for school attendance. So like the statute has exceptions for excused absences. And the court is like, we don't want to touch that with a 10-foot pole in this case. We're just looking at the unexcused ones.
Okay.
Which, Jamie, to your point, are the unexplained or irrational variations.
Got it.
But like, Jamie, to your point earlier about like, if I miss school every Tuesday, that's still technically regular because it is steady and uniform and there's no unexplained variations, right? I just miss school on Tuesdays.
Right.
And here's what kills me. The court here, the Missouri Supreme Court, cites to a previous case where they had to interpret the meaning of regular. And it involved a case where this home daycare services were being provided every Tuesday and Thursday with deviations for holidays and stuff. And the court concluded that the Tuesday and Thursday services were a regular provision of services because it followed a pattern and it didn't have unexplained deviation. So like here, and this obviously isn't what happened in this case, right? Like there's no pattern to these unexcused absences, but it just shows that like maybe this term regular has more give in it than the court is giving it credit for, where, you know, they interpret it to mean like you got to send your student to school every single day school is in session. Yeah. So I agree. Like that seems pretty extreme. If you miss that one day of school, you're in violation of the statute. And the court, to their credit, give them some credit, they acknowledge that.
Okay.
They say, yes, we recognize that this has some potential implications, but we're just doing our job. It's not our job to write the law.
We're just interpreting the law.
Exactly.
Yeah, you got a problem with it, go get mad at your legislators.
We didn't write the law. Be mad at them. And they point to the exceptions that I just talked about being mentally or physically unable to attend school. And they kind of say like that gives schools and parents flexibility with this distinction between unexcused and excused absences potentially.
Yeah.
And then they finally kind of say that, look, school officials have discretion about whether or not to report minor instances of noncompliance, and that prosecutors also have discretion about which cases to prosecute. So they're kind of saying like, yeah, one day could technically violate this statute if you're a no call, no show.
But they're saying there's a lot of padding in the system.
Right. Yeah. They're saying like, we trust schools enough to like not try to pursue that. And also if a prosecutor tried to bring that case, you know, they're going to get laughed out of court because like prosecutors have a lot of other stuff that they need to do. Like they're not going to want to, well, if a school came to a prosecutor and said, hey, I want to prosecute this parent for missing one day of school, that prosecutor is going to look at that parent like, you know, hey, I've got other things I need to get done.
Yeah. Yeah, exactly. Well, that kind of makes sense.
Right.
Yeah.
I don't know, though, that gives me enough comfort about like this very rigid view of what this attendance law requires. You know, this idea that like, oh, yeah, but other people are going to do their job. So it doesn't matter that we interpreted this law so broadly.
Right.
Especially when it's a criminal law with potential criminal implications. So like, you know, sure, other people might be doing their job and there might be those layers of padding, but that doesn't necessarily mean that's going to exist in every case. And it also doesn't mean that that's guaranteed.
Right.
Which just kind of reiterates my whole concern for using the criminal law to force school attendance. Recognizing, though, that we don't have a lot of other options.
Yeah, it's a tough one. I think this is, you know, especially since COVID and the fact that truancy has become much more of a challenge than it was before, and now it's even more of a challenge. Yeah, the mechanisms that we have in place to define what truancy is and then deal with it are in many cases problematic, or at least enough of a challenge.
For me, it comes back to root causes, right? Like, these don't things address root causes.
No, it's punitive for the most part.
Right.
Yeah, I mean, I think from a root cause standpoint, the only part of the system that is attempting to address that is the efforts that schools make to try to mitigate truancy. Right? They have attendance officers. They do home visits. They make phone calls. They say, what can we do to try to figure out how to get your kid to school? Right? They don't have unlimited resources. They obviously don't have unlimited manpower. This was one of the the big things that got a lot of attention during and sort of following COVID, right, is like, oh, wow, we've got some major attendance issues and we don't have the resources to do what we normally do on a scale that is needed now.
Right. Now that there's so many kids who have chronic absenteeism.
Right.
Right.
Yeah. But again, my point is, it doesn't seem like there's anything in the law or the regulations that attempt to address any of the root causes. That takes place at the school level.
Right. And putting it on the school, though, like the school, to you said, like they have limited resources and they also just like have limited influence, right? Like so many of these issues are larger systemic challenges where like, the challenges of school funding. So like if it's an issue with school funding, maybe they've had to cut bus services and now there's issues with bus coverage and maybe there's bus driver shortages, which I know a lot of school districts are dealing with.
Yeah.
But it could also just be something at the family level, right? Where like this family needs some support that the school is just not capable of providing. And so like putting this all on the school seems to be, again, not addressing those root causes and putting burdens on schools that they're not necessarily equipped, rightfully so perhaps, to handle.
I agree. And it's even beyond that. People are constantly criticizing schools. But, this is one of those classic cases where you are expecting the school to solve the problem that you are not attempting to solve.
Right. And that the school didn't cause.
Right. And and I'm basically referring to sort of state legislatures and things like that. Like you are basically saying all that we're going to do is punish people who are truant.
Right.
If you want to do more than that, that's on you, or if you want to try to avoid that, that's on you, school, and we're constantly criticizing, not me, but, as a society, we are constantly criticizing schools, for either doing too much or for not doing enough or whatever. And it's just like, this is one of those situations that really kind of frustrates me.
Right.
So anyway, schools, keep it up. You're doing good stuff with very limited resources. And listen, we completely understand that, the more students who are absent from your classes, the harder it is for you to actually meet your obligations, right? If you've got half your class out, it's harder to teach when there's no consistency there and when the students aren't there. And then you're, or they show up for, for the EOG tests and, those kinds of things.
Right. That's what I was going to throw in there is like this high accountability era, right? Like, If the students aren't there and you can't teach them, but you're still accountable for their learning, you can see why schools are really, really concerned about this.
100%.
Yeah.
Anyway.
Yeah, this is a tricky one.
That's what we'll leave you with, Chalk and Gavel listeners. It's a mess. It's a complete mess.
No, we fixed it. We didn't. Not this one. This one we didn't resolve.
Yeah. So that, folks, that is the case of the state of Missouri versus Williams. Very, very sort of complex, nuanced kind of issue that varies state by state. So, once again, like we say almost all the time, know your policies, right? Like that's one of the biggest takeaways is just be aware of your state and your district policies.
Which the school here seemed to do, and it worked out, right? Like the school did what they were doing. They sent the letters, they documented everything, and it worked. They had the receipts. So good on the school.
Exactly. Well, let's wrap this one up and bring it home, all right?
Your homework is to let your school know that you're a little bit tardy because you were finishing this podcast in your car, and to find us wherever you find your podcasts, like, rate, review, subscribe, tell a friend, share it with whoever you can think to share it with. We really appreciate you all listening and spreading the word. You can engage with us on social media at Chalk and Gavel, and we'd love to hear from you and continue the conversation.
All right, folks, we'll see you in 2 weeks where we present another case connecting the courtroom to the classroom.